Hello students, welcome to Legacy IAS Academy. In today's video, we are going to discuss about a recent petition that has been filed in the Supreme Court of India related to the criminalization of politics. And the question that has been put forward in the front of the judges of Supreme Court is, should convicted persons be allowed to contest election? So let us try to understand what this petition is all about and what has been the past judgment of Supreme Court in this regard, and also what is the overall stand of the central government as far as the criminalization of politics or the barring of people from contesting the election is concerned. Now, if you talk about the current petition, the recent petition which is being heard in the Supreme Court, the Apex Court of India, is filed by Ashwin Upadhyay and others. Now, in this particular petition, Ashwin Upadhyay and others have said that a lifetime ban should be imposed on those people who are convicted in the court from contesting any elections within the within the India. So the petitioners argue that the reason behind this is very simple. For example, if a person is convicted, he is not eligible to get even a junior grade government job, and on the other hand, he can become then lawmaker. So this does not make any sense. Even if we talk about we have the provisions of the ban on contesting elections, so that ban is for 6 years, for example. So even 6 years after serving of their sentence, they can come out, they can contest the election, and they can even win the election. So this is something that should be changed, it should be transformed, and that is what this petition is all about. Now, earlier in 2022, similar issue and question was raised back. In that time, the central government, in an affidavit that it filed before the court, it had mentioned that the MPs and MLAs are not bound by any service condition, which largely all the government servants are bound by. So their role, their responsibilities, their office cannot be equated with the office of government servant. And that is why the present disqualification period of 6 years that is given, we will discuss later, under the Representatives of People Act 1951, after the serving of sentence is adequate in nature. There is no need to change that. There is no need to put a permanent ban in the running of election or in winning the election. Now, the Supreme Court has again sought the response to the central government as well as the Election Commission of India on the current petition. Now, before also many times the judgment has been given by Supreme Court in this regard, and also while giving those judgments, Supreme Court has taken into consideration the legal provisions that is present in India, and this legal provision is largely present in the ROPA, that is the Representation of People Act 1951. Now, it has three salient provisions. The first provision is under Section 8, Clause 3. Now, what does this provision state? It says that a person is disqualified if he is convicted of a criminal offense and sentenced to imprisonment for not less than 2 years. In this case, he can be disqualified for contesting the election. Such a person is disqualified from contesting elections for how many years? For a further period of 6 years from the date of release. Now, suppose in this case, a person is convicted of a criminal offense and has been given a sentence of, let us suppose, 4 years. So obviously in these 4 years he cannot contest election, and even after being released from the jail at the end of 4 years, for the further period of 6 years will not be able to contest the election. So after the overall 10 years period, then he is free. Again, he can contest the election, win the election, and can get the political office as well. So this is the current standing provisions of Section 8 in the ROPA. The second provision is Section 8, Clause 1, which stipulates that a person convicted under criminal laws for the heinous crime will be disqualified irrespective of the period of their sentence and 6 years after release. That means here you have the minimum imprisonment for 2 years. Here you do not have any such minimum imprisonment case, but that is only for the heinous crime. What does heinous crime mean? Heinous crime can mean crimes such as rape, crimes such as the practice of untouchability, such crimes that come under the Prevention of Corruption Act and is we can say and is penalized under that particular act. So these kind of crimes do not have any minimum limit of what we can call as imprisonment. So here that is the second Section 8.1. And third section, which is again a controversial section, which again many of the legal luminaries and experts have asked to review it by the Supreme Court, that is Section 11. Now, under Section 11, Election Commission of India may remove any disqualification or even reduce the period of disqualification for a convicted person. And this is something that many times concern has been raised, that this power of Election Commission can be politicized. For example, election commissioners are appointed by the central government mostly. So in that case, if election commission is trying to favor the central government, then they can reduce the period of disqualification of the convicted person. And this is something that is not only theoretical, practically we have seen this happening in several cases in the past. So three major provisions under the ROPA. Now, as far as the matter being referred to the Supreme Court regarding the criminalization of politics is concerned, one of the major cases that was heard by the court was in the 2002 called as ADR case, that is Association for Democratic Reform case. It mandated the disclosure of criminal records of all candidates contesting elections so that the people who are voting for them can be aware about the criminal past of such candidates and can take the decision based on this particular divulging of information. So this was a welcome step. Second was CEC versus Jan Chaukidar case, that is the Chief Election Commission versus Jan Chaukidar case, heard in 2013. It upheld the creative interpretation of the provisions of the RP Act 1951 by the Patna High Court, as we can see. And in this case, one of the qualification as per the Act to contest election is that a person should be an elector. Now, elector is someone who is eligible to go and vote in the elections. So, under section 62(5) of the Act, it says that if a person is in jail, he is not eligible to vote in elections. That means he is not an elector. And if he is not an elector, that means he cannot contest the election. So, the court interpreted that person who are under trial prisoners therefore cease to be electors and hence not qualified to contest elections. So all under trial prisoners, as per this particular judgment of the Supreme Court, are barred from contesting election. However, the Parliament in the year 2013 amended the Act and then it overturned the judgment that was given by the court, and thus it allowed the under trial prisoners to contest the election. So this we can see many times. Even the court gives the judgment, the obviously Parliament has the power to overturn the judgment by amending the provisions of any particular act. Then in 2013 you have a very important case, very famous case of Lily Thomas versus Union of India, where under this particular case, hearing the petition, the Supreme Court struck down section 8 subclause 4 of the RP Act 1951, and it termed this particular act as unconstitutional and against political justice. Now, what this act was all about, or what this provision was all about? So, section 8(4) stated that a sitting legislator can continue as a member of the house. It can be house of Lok Sabha, it can be house of Rajya Sabha, or even at the state legislative assemblies and council. A legislator can continue to be a member even after conviction, given the condition they have filed an appeal against the conviction. For example, let us suppose a high court has convicted a sitting legislator. It does not mean that he will have to vacate his seat in the house. He can then appeal to the higher court, that is the Supreme Court obviously, and as long as the matter is under we can say under the appeal, we can say under the Supreme Court or under the Justice Supreme Court, he can continue to be a member of the house. After this judgment, a sitting legislature is disqualified immediately after the sentencing for a conviction. So this provision was struck down, and now a sitting legislature is disqualified immediately if the sentencing is given by the court for whatever conviction is there. Now, why we are talking about this case, it is very interestingly, if we talk about the criminalization of politics in India, as per the Association for Democratic Reforms, it has stated that in the year 2024, 46% of Q MPs have the criminal cases. And it is not for the first time that we are seeing such high figure. If you compare all the parliamentary elections, whether it is in 2009, 14, 19 and 24, we are seeing the number of MPs with criminal cases has hovered around 30% to 40%. And actually in 2024, what we are seeing is even highest number of people, highest number of MPs actually have the criminal cases if you compare it since 2009. So this is a very worrisome scenario. Not only that, ADR also has stated that there is an increase of 55% in the number of MPs with declared criminal cases since 2009 and increase of 124% in number of legislators with serious criminal cases, the heinous crime that we are talking about. So that is a worrisome scenario, and that is why criminalization of politics and decriminalization of politics is required, and the decision need to be taken here both by the Parliament as well as from the Supreme Court. Now, what can be the way forward going ahead? Now, if we look at again the ADR, it has stated that not only the presence of the MPs with criminal background hamper the political process, but also it does not give a level playing field to the people who want to contest the election. For example, as per the recent report has stated that a candidate who is contesting an election, if he has a criminal background, his chance of winning is 15.4%. On the other hand, a candidate with a clean background, no criminal cases, he has a lower chance of just 4.4%. So this is something that also is a worrisome trend. So the Law Commission in 1999 and 2014, before that also if talk about the Election Commission of India, in various occasions have highlighted the need to curb the criminalization of politics as it goes against the ethos of democratic country that we have tried to build since the independence. So even persons against whom charges are framed by competent court, in this regard, Law Commission has given a recommendation that we should not wait for the conviction, we should not wait for sentencing or final sentencing, but even those persons against whom charges are framed by a competent court for an offence that entails punishment for, let us say, more than 5 years, they should not be allowed to contest elections. So again, decision, or we can say the acceptance of this recommendation is still we have to witness. However, there has been no consensus on this recommendation amongst political parties considering the risk of its misuse, because obviously if this indeed becomes true or is included in the amended ROPA, then the political parties who are in power, they can use this as an instrument to target their opposition party members. So that is why both the parties are in power, who are in power right now, they know that later in the future they might have to again sit in the opposition. So that is why no consensus has built upon it. Now, apart from this, also we try to understand, as far as the current petition that we have been talking about, there may be convictions that do not involve moral turpitude. So for which cases permanent disqualification would be inappropriate and disproportionate. That means when you're talking about the permanent disqualification, it should not be applied uniformly across all kind of politicians with a criminal background. There should be case by case basis, we can also understand. So heinous crime and under statutes like the Prevention of Corruption Act, if someone is accused and convicted under these kind of criminal offences, then there may be a case for the lifetime disqualification. For other cases, there may be a longer period for disqualification. That is the change that we might want to see, as it is directly linked with the probity in public life. Now, meanwhile, the powers vested to the Election Commission for reducing or removing the period of disqualification, as we discussed before in the video, under section 11 of the ROPA, Election Commission has been given this power for the convicted person. This should be reviewed by the case for its constitutional validity, because it again does not do justice with the political justice. So that is all about this particular video. If you like the video, please hit the like button, share it with your full aspirants, as well as subscribe to our channel for more such content. Thank you very much.